raised hand to be called on? Okay, I'm getting just across the board, thumbs up. So it sounds like we're doing something good. Great. All right, so on to updates from the chair. One of the things I just wanted to acknowledge were the folks who sent in amendments in writing to us ahead of time. I think that's really going to help our discussions tonight, so that folks had the opportunity to really look at those amendments, members of the public could see them in their packet, and just make it a lot easier for us to talk about those amendments. So I just wanted to say thank you to the commissioners that were able to get that to us. I also wanted to acknowledge we are down to our last 2 months, folks. We've got a lot of work to do in a very short amount of time. So one of the things that I am going to shift to is having call on one person, or everyone gets one chance to talk about it, which is in our rules of order. We can amend that at a different point, but I feel like trying to make sure that if we are holding ourselves to that, I'm going to say these things one time, we might be able to keep moving our process along. Yes, Commissioner Rodelli.
Thank you, Madam Chair. Commissioner Rodelli, for a question. Does that include the person bringing forth the amendment? Okay. So the person bringing forth the amendment would speak, everyone else would speak, and then they have a chance to speak one more time.
Correct.
Great, thank you.
Yes, because the first time is more about giving information about the proposal. Commissioner Roby.
Commissioner Roby, District 3. Madam Chair, point of clarification. I thought we had to vote on changes like that. Did we vote the rules that you could change it? I thought we did part of one.
So I believe, and I would be very happy for anyone to point to the rules, but I believe that it is, especially in Robert's rules as well, up to the chair to decide how discussion will go. I'm very happy to have anyone call me to be able to point to something that says something else. I'm just wanting to make sure that we are continuing to move discussion along.
Our rules of procedure does address this.
Okay, great.
We agreed under rules of procedure, all members of the, wait a minute, it's not in, sorry.
Commissioner Roy.
Commissioner Ward, District 6. Just how long is it that each person gets to speak?
10 minutes. So yeah, that is 10 minutes at a go, if you would like to use that. Okay. Any additional discussion? Seeing none, on to legal report and pending request for analysis and advice. I'm getting the head shake, so it looks like we don't have any, which takes us on to listening sessions. I believe there was at least one this weekend. If folks would like to tell us about how that went. Commissioner Roby.
Yes, Commissioner Roby, District 3. We did have a listening session last Wednesday, and we had 2 people come. So, yeah, progress. And the main point of the discussion was that what I heard, and I would also refer to Commissioner Devin Willis with regards to what we heard, but I did hear that the people's voice is important. They indicated a lot of concern with the types of changes that are being suggested, larger government, when there's a freeze, and added positions in the charter when normally you don't add positions at staffing level, and then also wanting the elected sheriff versus the
Thank you. Commissioner Gann.
Thank you, Madam Chair. Commissioner Gann, District 4 had our last listening session last Wednesday, and I believe we had 9 people attend, and we talked about so many different things. I'm very can't summarize, but one thing of note, it's always interesting when people bring up concerns that aren't exactly charter related, but it did create a nice conversation around what avenues people have to advocate and what are their paths when they're concerned about things like traffic, where do they go in their local government to get those needs addressed. Thank you.
Thank you. Anything else around listening sessions? Great, well, that takes us on to amendment proposals. So for tonight, we're going to start with substantial discussion of amendment proposals previously advanced by 4 votes. And first up tonight is our first reading for C28, to replace the coroner with the medical examiner, I believe on page 25 of your packet. And just a reminder to everyone, all of these proposals are in packets, and that's why I use the page numbers so that folks are able to look at those directly as well. All right, so Commissioner Ward, Mulaski, and O'Leary, I'm not sure if you would like to speak to this proposal first. What's up, Commissioner Ward?
Commissioner for District 6, so I will speak to the amendment to replace the coroner with the medical examiner. Currently, our charter reflects that we have a coroner, using a coroner in our county. So a coroner is an older office, and Pierce County has been using the medical examiner model for over 42 years. A coroner is not necessarily medically trained. A medical examiner is a qualified medical professional, making that model more appropriate for Pierce County. So Pierce County already uses the medical examiner system. Charter still reflects the outdated coroner model. Pierce County is a large and growing county with an estimated population nearing 950,000 as of July 1, 2025. State law authorizes counties with populations over 250,000 to adopt a medical examiner system in place of the coroner system. I'm just trying to make this as brief as possible. So given the size of Pierce County and the number of types of deaths that occur here each year, it is important that death investigations be led by a trained medical professional with the qualifications required by state law. RCW 3024-1.90 provides that if counties adopting this model, the medical examiner must meet specific medical qualifications. And that's significant because of the amount of deaths that Pierce County is experiencing and the complications that could be surrounded by them. You want a medical professional determining what the causes of death are. So this is a technical amendment. It's important for operational clarity, legal consistency, and for public trust. Pierce County's longstanding medical examiner model, current county operations, modern forensic standards, and need for operational clarity, legal consistency, and public confidence is the reason for this amendment. Any questions?
Thank you, Commissioner Ward. Commissioner Gannon, looks like you'll start us off the discussion.
Thank you, and thank you to the commissioners who worked on this amendment. Just because I don't have Wi-Fi, the last paragraph of the proposed amendment language says Pierce County policy is that. Do you have the code number or where the Pierce County policy that refers to?
Regarding, can you repeat your question?
I'm sorry, yeah, the actual proposed amendment language, the underlined part, the last paragraph refers to Pierce County policy. And I don't see like in the rationale where, if there's a reference for that, like there is for the RCW.
Well, I'll have to find it. Yeah, I can get back to you on that. I know that we made the change and submitted it, but it must not have come through on this actual document, so.
I think it's on there, Commissioner, what she's referring to is the last paragraph of the proposed amendment. The statement in the amendment proposal says Pierce County policy is that medical death investigations be conducted through a professional, independent, medically and scientifically grounded system. So if I understand the question, it's where is that currently a policy, or is it a statement of intent that that's what they want the amendment to say?
That would be the intent. Let me ask the question.
Okay.
So,
It currently states that we have a coroner system.
it sounds like, especially since this is first reading, folks can always also talk with each other outside of the meeting to say, could we maybe shift this and then bring it for amendment for next time if it would help with clarity. Also, there is Wi-Fi, I think it's live Wi-Fi all over. But that's the password. Wireless, live wireless. All one word, all lowercase. So that helps. All right, Commissioner Glassby.
Thank you, Madam Chair. Just a suggestion, so I know when we write these amendments, we have to remember not to use the word policy, although I understand where it's going, but we're not using it in the right content. If I'm saying that correctly, so I see where she's going, we just have to not use the word policy, all right, because it is an RCW reference, but there's not a policy reference to that. But I understand what she's trying to say, but I really encourage you not to use the word policy in that restaurant.
Happy to work on language.
Commissioner Roby.
Commissioner Roby, District 3. In my research, I did find that this office of coroner transitioned from elected coroner to an appointed coroner in 1984, subsequently changed to medical examiner office. Right now, the verbiage does conflict in the charter with the actual operation and current practice. So this proposal cleans up verbiage, and it's also a good example as to why we shouldn't go beyond the head of the department or elected officials with regards to the charter, because the council and executive need flexibility to define positions and departments and operations. So leaving that up to the legislature is a good idea. Because this is in the charter, I recommend that we do go with this verbiage and change it to the medical examiner. I am supportive of this amendment. And with regards to the policy comment, it was pointed out by a member of the public earlier that we do, it does state earlier in the charter, for example, it is the policy of Pierce County to, and I'm paraphrasing because I don't have it in front of me, but it's the policy of Pierce County to participate in intergovernmental contracts whenever possible. And so I think what we're trying to do in this paragraph is state that it is a policy to utilize a medically trained doctor for this position, and it is an appointed position versus a coroner that is not medically trained. Thank you.
Any additional discussion on C28? Commissioner Stroud.
Thank you, Madam Chair. Commissioner Surratt, District 5. I have a couple of comments related to the writing of this proposal. It does seem, I should just go through it real briefly. That first sentence that's stricken, it looks like quite a bit of it could be simply retained for the language that is then following it, related to the arts hereby created the Executive Department Medical Examiner. I do wonder if it's a necessity for us to explain that Pierce County shall maintain a medical examiner system in lieu of a coroner system. Perhaps the sponsor has made such a determination and they determined that it's required. I guess long story short, I think I can assist with perhaps tightening up this language so that it's not as lengthy as it is, but still convey the same, information. Thank you.
Thank you, Commissioner Surratt. So in my research of this amendment, in talking to people, Commissioner, are you wanting to kind of take your turn to speak?
Because this is just, it's
Oh,
discussion.
you want me to, okay, I can answer.
If you'd like to use your, kind of your turn for tonight to answer that, that'd be great. So Commissioner Ward.
So Commissioner Ward, District 6. So in writing that language, what it does is it does require Pierce County to have this model of system versus not being able to just easily switch back to the coroner model, which, the medical examiner, is more appropriate for a county of this size and the amount and the types of deaths that, are being reviewed. So, and also when you have a coroner system, I believe there's, what happens with that office is there's a lot of contracting that goes out for some of these examinations and investigations. And so having a medical examiner, as a part of pre-established systems would be a time. But happy to work on language.
Commissioner Wilkins.
Thank you, Madam Chair. I'm just thinking about potential consequences sometimes when we put something out there, trying to think, of all sides of the issue. If this went out as it is now, and it was voted down by the public, technically, it seems the language would revert back to what is the coroner system, which isn't currently the system that's utilized by the county. So I think there's a little bit of a conundrum that in the wording and with legal experts, maybe we can get some advice on what options might help clarify that language without making it revert back to a system that isn't in place currently. Which, that could be a problem if it were to get voted down. Thanks.
Thank you. Commissioner Layton.
Thank you. Commissioner Layton, District 7. Since this is actually question time, right?
So it's not a question, we're at first reading, so it's just talking about the proposal.
Right, okay, so I'm a little concerned of how heavy this is in writing as other folks as well. So I'd like to also, Swad and Rogi, if you're willing, I was just looking at other county charters, it's very much more simple. It doesn't refer back to one system versus the other, it just simply says medical examiner and a few other qualifications. And we can simplify this down and kind of cut a lot of words out. So look forward to seeing if I can help with an amendment when this comes back. To clean it up, since it really is a technical change, we're already using a medical examiner, we just need to kind of clarify it in the charter.
I just love hearing so many people who want to work together, makes my heart happy. All right, Commissioner Randall Kelly.
Thank you, Commissioner Randall Kelly, District 4. I just want to echo Commissioner Lycan's questions about kind of the reverting back. I have the same concern with some of the stuff coming from the county executive's office around the CFO position and fix-it legislation that actually fixes stuff versus could create additional problems further down the line. I think it's really important to differentiate between that stuff. It's actually so concerning to me. I'm a big fan of the medical examiner system over coroner for many reasons, but don't want to create an unnecessary problem by accident here.
Any additional discussion for first reading on C28? Yes, Commissioner.
Thank you, Commissioner Herrera, District 2. I guess I just need a little clarification. I'm looking at the current website and it does already say medical examiner, but in the charter it says coroner. So are we just changing names or are we doing other things? Did I miss something or are we? Thank you.
Great question. So we are using the medical examiner model. We need to update the charter so that it reflects what we're actually doing and so that we ensure that we get the best investigations for our county and in-depth investigations that happen here.
All right, I don't see any additional discussion for C28, so that will move on to second reading next week. It sounds like there might be some reworking of some language, so if folks are working on that, remember it would be really helpful to get that in writing as early as possible so that everyone has a chance to really look at it and address it and come back for second reading with all the questions, possible answers, so we can really. All right, so that moves us on to C31, Executive Pro Tem, on page 27 of your packet. Commissioner Murphy, would you like to introduce this item?
Thank you, Madam Chair. Commissioner Roby, District 3. My amendment is for the Executive Pro Tem to, it's regarding that role. And this role provides a clear and prepared successor for temporary absences or disabilities of the executive with limited powers, no appointments or removals or vetoes. So it puts limitations on the power of this temporary position. My proposal by changing to, currently right now, they do have this model, and so I am supportive of this model, but my change requires the county council to annually elect a executive pro tem, because there has been some discussion around a potential gap in the vacancy. So my proposal ensures immediate seamless continued continuity of the executive functions. The pro tem can immediately handle day-to-day duties like signing documents, managing departments, and responding to crisis. Annual election ensures a ready and familiar leader. And it also promotes stability and public confidence. Pierce County residents deserve reliable executive leadership for budgets, public safety, emergency management, and services. And this allows the council to select the best suited member proactively, rather than defaulting to seniority or the current chair. This democratic internal selection process lets the body align the role with current priorities by an elected body. It facilitates smooth handling of prolonged or unexpected absences while the vacancy process is implemented and the position is filled. It strengthens checks and balances while bringing legislative knowledge or expertise. Annual election reinforces council oversight of the executive branch and ensures the acting leader understands both sides of government. This provision is smart and flexible. This provision is a smart and flexible tool for good governance, proactive rather than reactive, and beneficial for a growing county facing unpredictable challenges. And I do want to emphasize again that the pro tem, it does have limitations on the power, and it is accountable to people because it was elected by an elected official. And then with the annual review, it is, that action is reviewed on an annual basis, and the most qualified person would be elected to that position. Thank you.
Any discussion about C31? Seeing no discussion, that moves on to a second reading next week. All right, now we'll go to C38, voting requirements for charter review commission on page 29. Commissioner O'Leary, would you like to talk about this proposal?
Sure, thank you very much. Commissioner O'Leary, District 1. Just briefly, this amendment requires 2/3 vote of the Charter Review Commission to place any final proposed charter amendment on the ballot, ensuring that proposals reflect a broad bipartisan consensus-based agreement before submission to the voters. I put this forward because I feel that consensus building is critical, that we need to hear from a variety of voices and citizens, regardless of their economic stand, their geographic location, or the size of their constituency. It really makes people have to work together to try to find common ground, even though they disagree, they can come together to find a way to reach agreement. So I think that, again, I said it last time, that bringing the best of the best to the public is part of our responsibility. I think it ensures that minority voices are heard and not overlooked, and that members work together to find solutions that serve the whole county. Now, there may be some conversation or argument that a supermajority can allow a small minority to block the change. But I think it's just the opposite, quite frankly. That we need to find a way to bring things together so that a two-thirds majority better represents the entire county by enforcing a broader agreement, protecting minority voices, and ensuring that only widely supported changes are fundamental to the government that we move forward with. So it should be hard to put things on the chart. It should be difficult, and we should do the heavy lifting before we put it forward to the people. So that's why I came up with this, and certainly open for any discussion or suggestions. Thank you.
Thank you. Any discussion on C38, voting requirements for charter recognition? Commissioner Brody.
Thank you, Madam Chair. C38, voting requirements for charter review commission. Some would say it could make it more difficult to move items to the voters. However, I believe this is a worthwhile proposal. It does promote, I believe, it promotes broader consensus on a foundational document and encourages collaboration and litigation in a diverse county. It reduces the risk of poorly vetted and divisive proposals and reinforces our commission as a model of good governance. Thank you.
Commissioner Lee.
Thank you. Madam Chair, I move to amend this proposal by striking number 1 purpose in the second item. So just leaving the third item, voting requirements.
All right, so I'm gonna say it back and then let me, to make sure I got it right. So there's a motion to strike number 1 purpose, leaving only number 3. Does that match your?
Striking 1 and 2, paragraph 1 and 2, I guess, just leaving. But I'll speak to why if it's necessary.
I have a second from Commissioner Straub, so I'd love to speak to your motion.
I have said this before, indifferent about the purpose of this and what it does. It's more or less, if we're gonna be putting items into our charter, we don't have, our charter has a voice, and it doesn't use purpose statements, and it doesn't have, that type of language throughout. If you read our charter throughout it, we don't have those, and it's not really kind of how we've created our charter, so this actually would make it more consistent with how the voice, so to speak, of our charter is. And then on the second item there, that's already granted within our powers, within the charter review commission may propose amendments to this charter for submission. Like that's already within our purpose, it's already stated elsewhere, so just reiterating something that's not really needed. So this, to me, just cleans up that proposal here. Thank you.
Thank you. So discussion on the motion to strike paragraph 1 and 2, leaving only paragraph 3 voting requirement. Vice Chair Rentz?
Yeah, I would speak in support of that motion to amend, for the reasons just, Commissioner Layton said. I don't think, Commissioner O'Leary, that it alters the intent of your proposal at all. It just makes it much more simple. It doesn't state unnecessary background, what's left is what you are proposing, that there be a 2/3 vote, the why and the relationship to what the commission already has the power to do seems like it's not needed, and we can just get to the heart of the matter.
Commissioner Hammond?
Commissioner Hammond, District One. I do like this amendment of striking extra redundant language, and I keep thinking when you get to the ballot, and we may have several items on the ballot from the charter, it's best that we fine tune each item to the real nuts and bolts of what we want, and what changes the voter is voting for, and not have these lengthy paragraphs. So I do like this change, and for that reason of narrowing it down to really what we're trying to do.
Any additional discussion on the motion? And Commissioner Layton, I need your hands. Thank you. Seeing no additional discussion on the motion, I'd like to see the motion the motion on the table is to strike paragraphs 1 and 2, leaving only paragraph 3, voting requirements. All in favor of this amendment, please raise your cards, and your hand online. I see enough, I think, to make that motion pass. Alright, so now we will talk about the amendment or the proposal. All opposed. Sorry.
Clerk, do you need to actually count those?
Sorry, what was that?
Do you need to count the vote?
It is preferred, yes.
Okay, so let's do that since
I ran this through. So all in favor, please raise your cards and your hands online. Thank you, Vice Chair Lentz, for keeping me in line. And then all opposed? Any abstentions? All right, that motion passes. So now we'll go back to discussing the proposal as amended. Any additional discussion on the proposal as amended? Commissioner Rebecca.
Thank you, Madam Chair, Commissioner Rebecca, District 4. I highlight a couple things here. I think, first off, I think the total between commissioners, officials, and the public of amendments that came forth was somewhere around that. And we've had a lot of discussion here about how many should and could, and by what method they go to the ballot. And one thing I've actually heard over and over again from the public, including folks that are very not aligned with me politically, have said in our listening sessions that they think more should go to the ballot, not less. And it is up to us to be educated, and it is up to us to figure out what should go forward to the public. But as many of us have said here many times, they are the highest deciding body. They're the ones that get to make the decisions, not necessarily us. And I think there's an inherent tension here between requiring 2/3 majority for something like this and actual direct participatory democracy. I also find it concerning when there are other amendments that try to specify who can and can't participate in democracy. So I will be firmly opposed to this and think that it is not consensus building. I think it is limiting, and it is limiting the duly elected powers of the charter commissioners come from their people all over the county, and is limiting the democratic voice of our population. So I'm opposed to this amendment. Thank you.
Additional discussion. So Commissioner Hammond?
Thank you, Commissioner Hammond, District 1. I just want to say we've had a lot of great ideas, and there are great ideas, and there are excellent ideas. And perhaps by having this path, come through to the voters, what we are stating is that we're looking for the cream of the crop, the best of the best, and we're not trying to clutter
the ballot. That's another thing, is how do you choose? If you have limited numbers, which options should you choose? And I believe having this number of votes helps to make it a better quality product that we will give to the voters in the ultimate end.
Commissioner Ferreira. Thank you so much, Commissioner Ferreira, District 2. I am in favor of this amendment. I thank you, Commissioner O'Leary, for thinking out of the box and putting this forward. So my comments are, time and time again, we have seen, I review the public statements. I really take those to heart. And there's been overwhelming statements in favor of certain things and against certain things. And I really feel as a commission, we're not really listening to the public like we should. And that's what I ran for this position for. And I'm willing to do the work. However, good things keep getting voted down. And this is one good thing I would like to see put forward. I think it offers a lot of fairness, and it offers a lot of transparency, and it kind of shows where everybody stands. And I think it's just a feel-good kind of thing to do, and something that could offer our public some assurance that we're operating in their best interest. And that is what I believe in. Again, I thank you, Commissioner O'Leary, for thinking out of the box. This is amazing. Thank you so much. Commissioner Gonzalez.
Thank you, Madam Chair. Commissioner Control, District 6. As someone who is really big on lived experience, I feel like it's really difficult to sometimes bring in that perspective into spaces that are super, policy heavy, or areas that really aren't as open as they should be. And so I think, sometimes you do need that just extra 1%, past the post, to get into people. And that's what it is ultimately. I think when you're learning it already for the public to decide, I think that's where my hesitancy is. I'm also thinking about, and I know we always talk about voting in the voters, and I'm also thinking about the folks who are not registered to vote, or who may be taking this decision to vote for the first time. And I want them to have a sense of seeing themselves in the process, and there's a possibility that those amendments that might bring in that bridge for them might not reach the ballot in November. So I'm all about bringing in diverse perspectives, and I think it'd be easier for that to happen with the current situation that we have going on. And again, each charter gets to decide what they want to do. So if at the beginning they decide that 2/3 vote is what they're going to do for that decade, more power to them. Yeah, that's where I'm saying that as of right now.
Commissioner Rowley.
Thank you, Madam Chair. Commissioner Rowley, District 3. I wanted to make a comment that I disagree with one of the commissioners who stated that this was somehow limiting voter choice. The commission was voted, we were elected to help prioritize the people's voice and get changes to the public on a ballot that matter to them. And if I don't think that having the voters look at 10 or 20 opportunities to change the charter would bring about the kind of results that we want. I think it's our responsibility to listen to what the public wants, and I think it's our responsibility as elected officials to vet them and vet them well and have them worded well and make it easy for the public to understand what the change is and decide yes or no if they want the change. So, and I think that by increasing what goes to the voters by a 2/3 vote requirement is a responsible way to encourage collaboration and to make sure that what goes to the voters represents the wider county and what's good for the foundational document. Commissioner Layton.
Thank you, Madam Chair, Commissioner Layton, District 7 here. My amendment was simply to make sure that what we do present forward is something that keeps in mind the voice of our written charter. With that said, I'll be opposing this amendment. There's no secret that a 2/3 vote is not a leaf and follow the philosophy that I agree with. Hearing a lot of folks implying about responsibility and listening to voters, and I certainly take my job seriously that I was elected to by the voters in my district, which only required 50% plus one vote, by the way. And so, I think that I urge my commissioners to vote this amendment down when it comes to final vote at the next reading. Thank you.
Commissioner Heatherington.
Thank you, Chair. Commissioner Heatherington, District 2, and I just want to kind of think a lot of this, where my headspace is at Commissioner Consuelo kind of hit the nail on the head. I mean, any of our commissioners can make a motion that our procedures include a 2/3 vote, that anything that goes to the ballot. That's only a simple majority needs to, Commissioner O'Leary, you can make that amendment right now to our procedures. So that only needs a simple majority. As Commissioner Layton said, we were all voted to serve here as a simple majority. A simple majority gets the ballot, and it needs a simple majority by voters to change the charter. I mean, there's 3 layers here that I think that we don't need to change one to go to a 2/3 vote. So, like I said, any charter commission at the beginning, when they set up the procedures, can make that simple adjustment. So.
Commissioner O'Leary.
Thank you, Commissioner O'Leary, District 1. I just want to reiterate that this is all about consensus building. It isn't about blocking change, and it isn't about ensuring change. It's about ensuring that change is durable and widely supported and not driven by a temporary majority. And sooner or later, we're all going to have a temporary majority. But we're better together. We're better minds together. I've said it before, there's a lot of talented people in the room. And if people are willing to work together, we can put some very valuable things in front of the public. This is a once in a 10-year, this is a lifelong, eternal document for the county, and it's only reviewed once every 10 years. We should put forth the most effort, and we should find a way to work together. And this 2/3 majority requirement is a tool that helps ensure that kind of collaboration will happen. And unfortunately, we failed in that, in many cases so far. And whether this goes forward or not, I hope that we do better going forward. But we've had a lot of 12-9 votes here, and I found it to be really disappointing. And it's been called out by the public, and that's not something I'm proud of. So my intention for bringing this forward was to put something in the document that required consensus building, because that's where I think we get the best end product for the people. And that's what we were elected to do. So thank you, and I will be a yes vote.
Commissioner Fletcher.
Commissioner Fletcher, District 5. Thank you, Commissioner O'Leary, for this proposal. This does a couple of things I do enjoy. It does provide a reasonable way for this commission to work together in a greater capacity. I believe that the proposals that this commission works on from a greater number of people will have a better outcome. It will be a better product to provide to the voting public, who can then make an informed decision. This is every 10 years, so it is important to have general broad consensus on the items that we are bringing to make sure that they truly represent the county and not only a brief moment for the county or from one section of the county or point of view. So I think this does a lot of good things. I think any fear mongering of limiting democracy is baseless. Just because we get voted by a majority doesn't mean that everything we do can be passed by a simple majority. That's just circumstantial. But I do think also in cutting down some of the language to make it even more airtight, even the voter requirement section, I think we can shorten that and tighten that as well. But in effect, this body needs to be deliberate. This body requires more than a simple majority to make informed and well-crafted policy proposals or not policy proposals, but amendment proposals to the public, and this will do the job. So I am supporting this and happy to work with you, Commissioner O'Leary, on typing the language for your proposal.
All right, seeing no additional discussion, so C 38, is that right? Jerome, you're already saying we're done, we couldn't read it anymore. C 38, we'll move on, as amended, we'll move on to our agenda for next week. So next, we have C 14 and C 15, public safety stabilization. And I believe that Commissioner Lusby has a amendment to propose.
I'm bringing my notes just real quick.
And you'll need to make a motion as our leader.
Yes, so thank you, Madam Chair. We're speaking with Julie Demolf and Julie Murray in regards to what I want to try to accomplish. And correct me if I'm wrong, but C 14, C 15, we're looking at it being totally revised into one doc here. So the new section would be the public safety accountability and transparency. So what we're trying to accomplish is that the county should provide for independent review of public reporting regarding the performance, funding, and effectiveness of public safety services to promote transparency, accountability, and public trust. Public safety funding, including any dedicated restricted revenues established by ordinance such as justice funds or any successor funding mechanism shall support stability, continuity, and effective long-term planning across the public safety system. To the extent practicable, public safety funds, including those within the justice fund or any other successor funding mechanism, shall be used for the same or substantially similar purposes for which they were originally appropriated unless the county council provides a public explanation demonstrating that such reallocation will not materially impair stability or effectiveness of public safety services. The county council shall establish by ordinance or a process for regular public reporting on the public safety funding performance and independent advisory review of system-wide outcomes and coordination. So any advisory body created pursuant to this section shall be advisory only and shall not exercise budgetary, executive, or judicial authority. Implementation of this section shall be consistent with the Constitution and law of the state of Washington and shall not interfere with the authority of the courts or other independently elected officials. All reports, findings, and public explanation required under this section shall be made publicly available in a timely and accessible manner. The county council and county executive shall provide a public response to significant findings and recommendations issued through the process established under this section, and the process steps under this section shall include opportunities for public input regarding public safety funding and system performance. Once again, this was reviewed with both Julie and Julie D. Based on their recommendations, I created some revisions using some of the terms that they wanted me to implement in this document. And that's why I want to put it forward. The main thing is what we found is that accountability and transparency is the biggest gap right now for us, especially here on the county administration. Speaking with them too, they are making huge changes in regards to that across the board in some of the departments, which I was really happy to hear. From them, I think that by pursuing this and moving this forward, it would, I really believe that it will help resolve some of the issues that we are seeing today and hopefully build public trust. Thank you.
So Commissioner Morrissey, I do need a motion to amend C14 and C15 to combine them as you had provided the written, proposal. The written-
Thank you, Madam Chair. Yes, I would like to make a motion, to combine C14, C15 to the new proposal that was spoken.
Second.
All right, I have a second from Commissioner Surratt. So we are on to discussion of the amendment first, and then we're going to bring it back to general discussion of the content. That's your lens.
I'm in favor of the amendment for the reason that if anybody comes forward with a reworked proposal, I will be in favor of that amendment, so we can have a discussion on the proposal as the sponsor has perfected it and as the sponsor wants to present it. So I am voting yes on this amendment.
Commissioner Murphy, did you have any additional discussion on the amendment itself? Seeing none, all in favor of the amendment to the proposal to combine C14 and C15 as stated? Please raise your cards. And then all opposed, please raise your hands. Seeing none. Any abstentions? All right, so that motion passes. So now we are talking about the proposal as amended. So really looking at what is on page 35 of your packet and letting go of everything that was there before. Because there was a lot of work that was done to rework everything. So let's make sure we're focusing on the proposal as amended. So now on to discussion. Do want to make sure, in Commissioner Musk, is there anything additionally you want to say about the proposal as a whole now?
But, yes, the biggest thing was working together with Julie DeMose, Julie and Mari in regards to ensuring that the language really meant that would work in the county. But the other thing, what was awesome about this is that the same thing that I have proposed, we found out that they're working on something similar internally, which we were kind of excited that we were on the same page on. So I really believe this would be a good fit for the charter to be placed as an amendment, seeing that we're both aligned with the same purpose, the same goal, the same outcome.
All right. Commissioner Kelly.
Thank you, Madam Chair, and thank you, Commissioner Morrissey. This is Kelly's report. I guess I have a couple questions or concerns about this. The first is, this is much more simple and straightforward, so that's great, and I do support doing that. Section A, discussing intent review and public reporting, it doesn't really, I don't really understand or have a lot of clarity about what end or what intent review or public reporting is used for, especially in how it relates to the PNC in particular. It seems like a multi-subject thing. And then, really interestingly, right, like when these kind of things are included as subclauses in the same space, there's an implication that they're connected and related. And C, A, it sounds like there's some kind of public reporting for accountability, transparency, trust. And C, it sounds like there's a guarantee that underutilized funds from a given year will be appropriated for the same utilization in subsequent years. And those seem, in a way, almost contradictory to me. Like, what if the reporting is that the funds weren't going to use right, and therefore, it shouldn't be appropriated the exact same way. That seems like it creates a weird kind of just odd situation, and then I'm having trouble wrestling through. So that's it. It's a mixture of a comment and a question, I guess.
Thank you, Commissioner White. I will speak with both Julian and Dean about that, but the language we were trying to portray was that we will be establishing a system which is a transparency and accountability with the advisory panel or advisory panel, so that we're ensuring that things are being done as implemented or stated in whatever programs that they're using. We can't enforce anything. The one thing there in C, I will go back over it again with them. The main thing is where it says, when we talk about within the justice fund, that's the new process that they're implementing as well, which is kind of in line with what I'm trying to accomplish. So I will check the wording to make sure it's clear and concise, but we're trying not to make it contradictory or redundancy. So if you can do me a favor, because the salary of the room is still offering me, can you please email me that same concern so that I can be able to adjust that again?
There's a head shake. I don't know, you all probably don't know, most of the video is just the corner of the room. So most folks can't really see us. So if there's something you're wanting to communicate to people online, say there's like, you might not know otherwise. But I saw a head nod, so I think we're good there. Any additional discussion on the amendment or the proposal as amended? Commissioner Gill.
Thank you, Madam Chair. Commissioner Ginn, I think this is a question, and I'm looking at the Justice Fund. So the Performance Advisory Board that was created specifically for the Justice Fund, this Commissioner Molesky, you're proposing a separate advisory body for public safety funding in general, and with this, that's my confusion. Thank you.
That's the point. That's the purpose of that. From what I found out speaking with Julie, MD, especially some other departments, they have their own internal panel that they use, but it does not service the public in regards to information distribution, so the public will know what's going on. So that is the thing, but if it's not clear enough on that, then I need to go back and make clarity on it. But that was the purpose of this proposal, is that there is a public accountability and transparency. We're also a public, also be part of this advisory panel to ensure that those tasks are taken. But once again, if you can just email it up, I get to the summary side, I'm trying to pick up everything that you're exactly saying. If you can just email that to me so I can work on that as well, that'd be helpful.
I'm also getting a head nod from Commissioner Gill. All right, I do not see any other hands or cards for discussion, so that means we will move the new combined C14, C15 to next week, and we'll give it a new number just to make it easier to not say that over and over and over again. All right, so that now, because we amended the agenda, we are now on to C3R, C4R, and C5R vacancies in office, starting on page 47 of your packet. Commissioner Sorrell, you have an amendment to tell us about.
Thank you, Madam Chair. I move to consolidate proposals C3R1, C4R, and C5R, along with C9, which is going to receive its second reading tonight, and revise as shown in the amended packet starting on page 54.
I have a motion to consolidate C3R, C4R, C5R, and C9 as shown in the revised packet. Second by Commissioner Hunter. Discussion on the amendment to combine all those. So I have Commissioner Heatherington. Yes, please. Commissioner Sorrell, please. Go ahead.
I'm going to ramble a little bit, but here we are. A significant amount of time has passed since I first introduced these proposals back in February, but of course during that time there has been a consistent ongoing process for refinement. I just want to thank all staff, elected officials, public commenters who have helped inform this proposal.
Pardon me, point of order, yes, we voted to on the combination of the amendments.
There's a motion and a second.
So
He's speaking to the
Oh,
motion.
okay, the reason, okay, I apologize.
No worries. The proposal before you would delete section 3.40, executive pro tem board, and rewrite section 4.70 into a complete system governing vacancies, suspension, and acting authority. The main objectives here are to add precision and clarity to the charter to eliminate any outstanding concerns about how our charter interacts with general law in these areas, deliver more accountability to the public from our elected officials in the performance of their duties, and ensure continuity of government under all conditions. If you go with me, I'm going to go through this subsection by subsection. If you go to your page 54, you'll see subsection 1. This concerns vacancy triggers. What this new proposal will do is add to the list of vacancy triggers felonies. A new trigger for qualifying gross misdemeanors tied to misconduct related to elective county office. A new trigger for council declared vacancy in subsection 6, which we'll talk about shortly, and an adoption by reference of general law governing vacancies. This is going to eliminate any uncertainty about whether state vacancy statutes apply to our home rule charter county. It moves us from an incomplete list to a comprehensive and integrated one. And it's going to ensure, or help ensure, that certain types of serious misconduct are prominently noted as a vacancy trigger. Moving to subsection 2, a key organizational note here. The existing charter, subsection 2, squeezes multiple concepts into a single employment paragraph here. The proposal before you tonight splits existing subsection 2 into parts. And that's going to allow for subsection 2 to govern partisan vacancies. Subsection 3 will govern nonpartisan vacancies, and it will relocate the existing subsection 3 to subsection 4 without any changes to the text. And of course, all subsequent paragraphs will be remembered accordingly. And this organizational change will create clear separation between legally distinct employment processes. It's going to provide some space for a fully developed employment process description, and it's going to replace that compressing, unclear subsection with a more understandable structure. Back to subsection 2 of this proposal. What it specifically does is clarify that it applies to all partisan elective offices, regardless of whether or not their party is quote-unquote nature. It makes changes to language that I find to be very unclear, including, quote, in office immediately prior to the declaration of vacancy restricted. Additionally, it makes key process enhancements on top of those already required by general law. It's going to add a requirement to request candidate materials, a requirement to publish any materials that are received from partisan candidates. It requires public interviews, and it also requires a 20-day deadline for council to make an appointment. There's now consequences for inaction should council not do so. That would be weekly meetings with mandatory roll call votes and strict limits on council business. This subsection has to work within the framework of the state constitution, Article 2, Section 15, and that is the legislative authority will make an appointment, but if they don't do so within 60 days, that's transferred to the governor, who has to make an appointment from that very same list. So this subsection will preserve local control, or at least attempt to, ensure that the council fulfills its role before the authority shifts to the governor. It introduces new transparency and accountability measures, and it helps prevent council inaction for partisan appointments. Subsection 3 would then govern nonpartisan vacancy appointments. What this will do is establish a defined nonpartisan appointment process where none exists today. It requires a public notice, a minimum 20-day application period, publication of applicant materials, public interviews and review. And what this would do is fill a clear gap in charter, code, and general law, none of which meaningfully address nonpartisan appointments. It moves the charter from having no defined process here at all to one that is transparent and competitive, and it ensures fairness and legitimacy. Moving on to subsection 4, as I said, there's no changes here beyond moving from the text of 3 to 4. There's no other edits here, and that's a good thing. This subsection should be retained. It returns ultimate authority back to the voters, and keeping it at subsection 4, or having it be at subsection 4, is a good logical sequencing there. Moving on to subsection 5, This concerns suspension and removal of elected officials. What it does is expand triggers. It expands the trigger with gross misdemeanors tied to official misconduct in a county office. And it does so by referencing Title IX Arsonetti, Washington State Criminal Code, and Title 42 RCW Public Officers and Agencies. The existing mechanism within this subsection is retained, and that's suspension with pay and removal upon conviction. But it clarifies in the charter for the first time ever who exercises the power of the suspended official during a suspension and who designates acting officials during suspension. The authority structure is clear and simple. If the executive is suspended, the council will designate an acting executive. If other executive branch officials are suspended, the executive shall designate an acting official. These designations would override any designation made by a suspended official. There's great improvements here, I argue. It strengthens the separation of powers with clear lines of authority. The executive, as the CEO of the county, manages the executive branch when needed, and the council retains authority at the highest level by appointing an acting executive when needed. This ensures continuity and legitimacy during suspensions and convictions. It eliminates uncertainty about who is in charge during a suspension and after a removal, and it provides stable leadership while due process proceeds and key services continue. Moving on to subsection 6, this would be a vacancy by a civil judgment. And what this does is create a new vacancy here that council may exercise when a final judgment is entered, appeals are exhausted or waived, and that there is a county liability of $1 million or more that is tied to willful, unlawful conduct in office. This requires implementation by ordinance, and of course, it will have to consider due process protections here. Some context is important for this one. This subsection has undergone major revisions since February, when it was introduced under Proposal C5. There's been a lot of hard work to ensure that a new accountability mechanism is created here, and frankly, those are tough to craft. The proposal before you tonight was informed by many legal reviews, and the result is a provision that is more precise and limited in scope to what was here before. It adds a targeted accountability mechanism with a high threshold. It ensures only serious and adjudicated misconduct will trigger removal, and it addresses cases not covered by existing vacancy triggers. Moving on to subsection 7, this will be a new acting officials framework. And what it does is replace the executive pro tempore section of 3.40 with a modern acting designation framework. It's going to require written designation by each elected executive branch official of their choosing for an acting official. That would then be filed with the auditor, and an oath of office would be required for that designated acting official. It provides full authority to acting officials during their service. And it adds an executive lifecycle if no designation exists. So just to repeat, under this proposal, if an acting official designation has been made by an elected official, that designation governs, and there's no issue. But if no designation exists during a time of need, the executive appoints an acting official from the salaried employees of that office. This is going to establish a clear chain of command across all executive offices, and it aligns authority with the charter structure approved by voters in Pierce County. It also affirms the purpose of the executive role, and that they will control centralized administrative oversight and accountability. It also reserves some uncertainty created by statute for commission forms of county government that lack an executive branch. This proposal, I hope, is going to help ensure that no gaps in leadership nor any confusion related to there being several deputies in an office exist, and it enhances accountability by requiring that acting officials be an existing employee of the office. I'm going to end by talking briefly about why we need to delete Executive Person Order 3.40. This proposal removes an outdated and very limited role, and it's also one, as Commissioner Rogie has clarified earlier, that's not even required by this current charter. This proposal is going to replace that very limited backup role and do so with a scalable and modern acting official system. And that reflects the reality of a large and complex executive organization with a multi-billion-dollar budget. This executive branch needs nimble and efficient leadership. This proposal does build on my former C9 proposal for a deputy executive, but now it's going to transition to a consistent acting authority that in some ways is already reflected in practice. I do want to note that the current executive pro tempore and the deputy executive of Pierce County will support replacing 3.40 executive pro tempore with an acting authority concept like the one found in this proposal. So I ask for your support in adopting this amendment for this proposal.
All right, so that brings us to discussion. Commissioner Heatherington.
You have on the agenda legal review if you want. Is there any legal review?
Well, we need to do the motion, we need to complete the motion, and then we'll go on to the legal review.
Thank you, Commissioner Sherrod, for providing all these. I do have a procedural question then. Are we removing off the agenda C9 for second reading then and bumping everything back into this first reading?
So when we get to C9, I believe we will have a motion to remove that.
Okay. After this is approved. Okay, thank you.
Commissioner Vice Chair Lenz.
Thank you. I just wanted to speak my support to this amendment to be consistent with what I said with regard to previous sponsor requested amendments to their proposals. I am in favor of the amendment for the reason that I believe that the sponsoring commissioner should have presented the ability to present to the body the most clearest and the most comprehensive version of their proposal. So I am in favor of this amendment.
So no additional discussion on the amendment. We have a motion before us to consolidate C3R, C4R, C5R, and C9 as revised in the packet. All in favor of this amendment, please raise your cards. All opposed? Any abstentions? Abstention? All right, so the motion passes to now have all of those proposals together in one. So that is what we will be talking about from here on out. And we do have a new legal review on that proposal as amended.
The amendment is, the changes in the amendment are within the authority of the Charter County. The legal review is on page 58 of the packet. There is some commentary about one provision that's just very highly unlikely to go. Thank you.
All right, so now on to discussion of the proposal as amended. Commissioner Murphy.
Thank you, Madam Chair, Commissioner Roby, District 3. I believe the council removal power is likely unconstitutional. And to declare a vacant by simple resolution, a vacancy whenever a court judgment is $1 million or more, why add this? Any elected official can be suspended with full pay on nothing more than an indictment or even a gross misdemeanor or change. It paralyzes the government. It basically creates mandatory furlough and a state rule. So the council can pay, they can suspend an elected official and pay them through the court case, which can take years. A single stubborn council faction could shut down business for weeks or months. And what about emergencies and serving the people? Any elected official can redesignate a salaried employee, and the acting official gets all the powers of the elected official. Who would be their boss? Massive new bureaucracy and red tape for filling vacancies. It adds mandatory public requests for applications, published resumes, public interviews, and multi-round interviews, all on top of a 20-day forced meeting rule. It sounds transparent, but in practice, it will slow everything down, invite litigation, over-process, and make county government harder. Vague, expansive language terms like knowing and willful unlawful conduct with official duties, misuse of public resources, falsification of concealment of public records, all broad enough that a majority council could stretch and vote out someone they don't like, and then add out in the combined 1 million trigger. It could lead to selective enforcement, unnecessary complexity, masquerades as modernization. Instead of protecting taxpayers and respecting voters that elected these officials, this amendment gives politicians new tools to suspend, sideline, and replace each other. All while paying suspended officials and the council is forced to ignore everything else. It's not reform, it's power grab dressed up as accountability. This is a no for me. Any additional discussion? Commissioner Boyd.
Commissioner Boyd, District 6, I am in support of this, and I appreciate the complexity and the clarity around what is here really spells out why. Legally and transparently for everyone to know. There's rules that are governing everyone, every employee of the county. And these are explicit. These are ones that are easily understandable by those who have read it and given me context of why they appreciate having it layered down in a way that they can understand. And it's not about partisan antics. It's about holding people accountable with clear boundaries. Clear boundaries. And I think everyone would understand that as their business. So I am in favor of this.
Commissioner Gonzalez?
No, it was up to bat. Thank you, Madam Chair, Commissioner Consuelo, District 6. I get the worry of this possibly being weaponized, but it would, in my opinion, you wouldn't weaponize it against an opponent you don't like. I feel like it would be easier for you to put in a false, claim, have a candidate or an elected official that you like end up having a month-long, vacation. But at the end of the day, if it's a false claim, like the elected official will come back and continue to serve out their term. And that's a hypothetical, but more what we've seen and in this colorful history of Pierce County with corruption and the current corruption that we have on the federal level, I want to keep my elected officials accountable, especially when it comes to crimes or benefiting behavior. And so this is a very comprehensive list of what to look out for. And going in line kind of with the same sense of culture as I spoke about in the sheriff's office. If you have a high profile person and you are underneath them and you see that there's possibly corruption or some malfeasance going on, you might not be as inclined to speak up about it if there aren't clear guidelines or, there isn't a sense of confidence that you can bring this up and that something will happen. But this clearly lays it out, and I think if I were in that position, I would be more comfortable saying that, yes, this is supported, yes, this is something that I can do. And yeah, I mean, I would want to nip this at the bud if there is some form of wrongdoing. So why give someone, especially with limited limits, to make all council seats 3 terms? Why would you create council seats and then have them be prosecuted after? Like, if they're already doing wrong things, I want them to get caught in the moment. So yeah, that's me.
Commissioner Ferrer.
Thank you, Commissioner Ferrera, District 2. Couple questions and a couple comments. What's broken? We heard from some very prominent people about a month and a half ago, and they cautioned us to focus on what's broken. And I don't see this amendment addressing that. We talked 20 minutes ago about 2 previous amendments that were amended because they were wordy and lengthy and, needed to be cleaned up, I believe the wording was. And here we are again with a very wordy, lengthy amendment. And I believe some of the comments were easily understandable. And who would the appointed person report to? That's the question that I have. And also, back to being wordy, our voters, they just want, it's very basic, they just want good leaders who act and vote and advocate for their best interest, and that's what we have to remember. And we all know this. And I guess I would, a couple of other things in this amendment, I'd like to also clarify in some of the points here, define what a gross misdemeanor is to you. Does that include like DUIs? I'm not a legal person, I'm not an attorney, it sounds very partisan and possibly even maybe an attack on someone. Is there something that I'm missing here or don't know about? Maybe that can be clarified. Again, I caution being partisan on a nonpartisan commission. I caution us on that. Because again, and I'll state it again, I don't feel like we're acting in the best interest of the public. We're ignoring the public's requests and what they're saying, and the majority are saying something, and we're just pushing these amendments through with the same 11 votes. And I feel like my voice is not being heard. I feel like a lot of voices are not being heard here, and I caution again, we're acting in the best interest of the public. And our names are on these amendments that we will have to live with for 10 years. So you can either vote for your friends, or you can vote with your friends or with the public who elected us. So that being said, let's see. I guess another question I would have is this affecting people sitting in office now? Do we need to look into everybody's background for, if they've committed crimes in the past? This is so extensive and kind of crazy. I agree it masquerades as modernization, and I think it's just a amendment that's being put forward in the guise and for someone else. Thank you.
Commissioner
Commissioner Hammack.
Commissioner Hammack, District 1. What concerns me is the language, of course, it's just blacked out on my notes. The language on number 6 where it says, an elected office may be declared vacant by the council, which tells me that you have 7 members that say this position is vacant. With, I'm not even, it might be warranted, but to have 7 members, the state law has a procedure in which you are declared a vacant office, where an elected position declared vacant. That procedure can happen only at certain times, and there is a certain process under state law to declare somebody bad enough to do the recall to make that position vacant. So I am concerned that you're allowing 7 members to make that declaration. Now, I could see changing it so that 7 members have a pathway to go through the process of having the vote to have a recall situation and then declare it vacant. But not to have 7 members declare the position vacant and the person is gone. There is a process under state law that all of this bypasses. And so that is a big concern to me, to not be following state law practices of declaring vacancies for an elected official. And we have seen this. I'm sure many of us who have gone through the political system have seen PCOs that we don't like or that have done wrong things and we want to get rid of them. But we can't even get rid of our own PCOs because of this process. They are an elected official, and now we have to declare a vacancy. You can take them and strip them of the party, but you cannot declare them a vacancy. So how can you declare an elected office a vacancy just on the vote of 7 members versus an entire recall process? That's what I'm struggling with. The parts of the law that is about replacing a vacancy, I can see a lot of that makes sense, but the declaration of a vacancy, even if someone has done something egregious and bad, then they have to go through a recall process. So that's what I can see happening, where the 7 members have some kind of way to start the recall process, but not to just declare the vacancy. So, thank you.
Commissioner Rebecca.
Thank you, Madam Chair, Commissioner Kelly, and thank you also, Commissioner Surratt, for your technical expertise. It continues to impress me with how some of these decisions. I also appreciate that these are consolidated. I just want to highlight a couple things here. While I think this is really working, it might be difficult for voters to understand. I also think it's great, and I think there might be some additional small workshopping to improve it. I think it's overwhelmingly good. And I want to highlight a couple of the comments that have been brought up by the commissioners here about it. I don't think there's any route where this is going to enable somehow some bureaucratic partisan crime off, where a bunch of electeds are either committing crimes and being held accountable for committing crimes locally, or going to civil court and being found, with over $1 million in penalties. And I would turn everyone's attention to, like the EPA said in their legal review, that the Section 6 outcomes are extremely unlikely unless we just get really bad elected officials, and many of them committing a bunch of crimes. I don't think those concerns are really valid. I do think that there's a lot of stuff in here that's also been brought up that is already in one way or another common practice. Common practice in that these are unlikely, uncommon events, but when they do happen, elected officials have been suspended without pay and have had to work this out for years and elsewhere. So I think that, like, some of this stuff is common practice, but it's not codified in a way that is accountable and enforceable. And what Commissioner Scott is trying to do is make it clear when that counts. And there are very strict, clear definitions of what a gross misdemeanor is. We can talk about that in our conversation tonight. The whole point is that this provides clarity and actionable clarity. It is not just a giveaway for partisan politics or some members of the council. It's mechanisms and methods for accountability when crime is being committed or gross negligence is being committed by elected, that is currently lacking in the recall process, which is too prohibitive. So I am fully supportive of this, even though I think it combines a lot of second one, and I hope there's a way to make it as accessible as possible to voters.
Commissioner Willis?
Commissioner Willis, District 3, thank you, Madam Chair. Got a ton of notes. I don't want to take a whole ton of time on this, but a couple, it's not as wordy as this. A couple of points that I wrote down that are huge concerns that have been also brought up in other proposals that seem to kind of tie this together. Correct me if I'm wrong, Mr. Sarad, but it looks like this is strategic bundling. Obviously, 3, 4, and 5, 3 was not bad. 4 was okay. 5, really, I had a lot of issues with that. I was kind of waiting to get further down the road to be able to talk about 5 individually, but now that they're all together, here we are. So I look at this as strategic bundling. First, when I look at section 4.70 vacancies, I do have to ask, is the charter's vacancy rules too party-driven, too colorful, too weak? Which kind of derive and work C, 3, 4, and 5. Because I do see it as being a combination of all 3, but my fear is that in strategically bundling all 3 of these, it looks like there's 2 issues that I can see through this, correct me if I'm wrong, please, but I look at this as a political control tool that, for example, would limit the sheriff's independence and give countywide executives leadership, more practical control in conflict scenarios. If I'm wrong with that, please correct me, but that'd be a big concern because, again, these are elected individuals, and if they haven't, for example, the sheriff is so heated, if they haven't committed malfeasance, misfeasance, or oath of office, and there's just simply a complaint, could this be utilized to stifle or remove or silence them through practical controls? And then another issue would be, I don't know, I kind of feel this is a ballot strategy move because this is a major structural change in 4.70, and I'm worried that the voters would reject it if they truly knew some of the underlying motive here. It's not very clear to me. It's very wordy. One of the other commissioners notes here earlier that, hey, let's get rid of this, let's get rid of that, let's get right down meat and potatoes. I feel like there's like a side garden salad with like a smorgasbord of different things here. And that's, again, combining this all together, but I just feel like there's a lot. And I don't know how you're going to propose this to the public, but I wish you'd justify that. I do see that C5 itself, it gives the executive a lot of power over elected officials, and that's a huge concern because, as George Orwell once said, all animals are created equal. Some animals are equal than others. I believe this sets precedents of normalizing removal, and that my fear of that is that it could be a sheriff today, and then it could be another elected official tomorrow, and this sets a very dangerous path for that going forward. That's my comments.
Commissioner Lee?
Thank you, Commissioner Lee, District 7 here. Want to point out that I am listening to my constituents. I do talk to them, so there's kind of the implication that somehow we're not listening because we disagree on a matter is kind of implying things I don't necessarily think is meant to be. But in that matter, I do want to point out that gross misdemeanor is in statute and state law. There's a definition of it. So it's not a made up term. It's not something that is just out there in the ether. It's described in state criminal code. Crimes other than felonies and misdemeanors, they are off. Offenses that are seen as serious wrongdoing that fail just short of felony. Examples are assault in the fourth degree, harassment, violation of non-contract order, obstruction of police officer, driving under influence. So these are actual, really, offensive things, so it's not like capturing anything else. I do agree, I'll be supporting this moving forward, but I do hope that Commissioner Surratt can find ways to condense what he's trying to do in a lot of this. It is quite long, and I'm hoping that, there's a way to kind of shorten much of this down a bit, and to try to just get to the point. But I'll be supporting it moving forward in hopes that, we can find a way to, keep kind of getting it shorter. Thank you.
Vice Chair Lentz?
I am supportive of this concept for making certainty as to when these triggers occurred, such that there would be suspension or declaration of a vacancy. I'm a little bit perplexed with the statements that this is overly partisan. I don't see how that it is. What it is a list of objective criteria. These aren't things that are just made up, they aren't subjective. They're all things that we know when they happen, and they apply equally to whoever's in office, regardless of party. And I would just go through some of these things. The triggers are an elective office becomes vacant when, and it just adds a few things, conviction of a felony. Do we want to support convicted felons remaining in office? I mean, I'm not sure. That goes across party lines. It doesn't apply to one particular party or another. Conviction of a gross misdemeanor, that was just discussed. I would add that this particular language, though, links the gross misdemeanor to conduct in county office involving official misconduct, misuse of public resources, or falsification or concealment of public records. Not all gross misdemeanors in and of themselves are a trigger. It's very specific things related to the performance of the office. On subsection 2, regarding vacancies in partisan offices, these things that are being added are clarifications and some additional criteria, but already when there's a vacancy in partisan office, the county council already takes lists of names, they already take essentially an application. These additional requirements are to let the public know who has applied for and who is being considered to be replacing a vacated office that they, the members of the public, elected. To me, it just seems not partisan at all. It seems really straightforward. Why wouldn't we want information and a fair process within the partisan abilities of the political parties to participate in that? I don't think it changes anything. With regard to the suspension, former subsection 4, new subsection 5, it already says in the charter that an elected official is suspended with pay upon an information or indictment of a felony charge being filed against them. What it adds, so we're already allowing suspensions with pay if somebody's charged with a felony, or if they're indicted for it. What it adds again is that specific types of gross misdemeanors specifically related to conduct in office as another trigger for suspension. Again, these things aren't subjective, they're not able to be applied inconsistently. If it happens, it happens. And with regard to, so again, these are things that are already in the law, we're already doing it. With regard to the designations of an employee to act as the acting if the head of office or the elected official or the is away. Again, I think this is just very straightforward. It's not partisan at all. It simply sets out a very clear way that everybody knows, regardless of party, regardless of office, that you need to designate somebody to fill in for you, and you need to file that with the auditor. And then finally, with regard to the change that fills the backup, I guess, or the designate delegate, in across all offices and replaces the current system under Article 3, where the council appoints a pro tem to fill in for the executive. I think that's an improvement, and I think the reason why is because it seems like a separation of powers, consideration and concern the way that it's done already. I acknowledging Commissioner Roby's proposal that it doesn't even require it, but the point is that the council, the legislative branch, designates a member of the legislative branch to act instead of the executive, which seems like a problem and seems like an ability to generate conflicts of interest, where you could have your appointed legislative person acting as the executive, and I think it's much clearer for the, to follow the lines of this proposal to very objectively, very clearly, in all cases, have a designee, delegate on file, and then everybody knows that's who we turn to. So again, I would support this. I don't have any issues with working on trying to make it a little more simple. Maybe there's some things that aren't as compelling as others, but I really don't think that it's partisan. I don't think that it's intended to somehow do something untoward. I think it's quite the opposite, that it's intended to demonstrate clarity, objectivity, and transparency.
Commissioner Sherrill?
Thank you, Madam Chair. Commissioner Surratt, District 5. I'm going to first just state that I flatly reject the accusation that this proposal is submitted with some element of partisanship, being some foundational element in its crafting. And I flatly reject that it was submitted or crafted by somebody else and submitted on their behalf. This proposal actually originates with discussions from the public. Discussions from the public generally centered on them really valuing their elected officials and having the power to vote for those elected officials, to include the sheriff. But universally, including in public comments to this body, people want more accountability measures. Well, here they are. These are very basic accountability measures to enshrine into the charter. I don't want our public officials betraying our trust through official misconduct that is clearly articulated, and those are standards that I list within the charter. If you, in fact, are favorable if you actually are okay with misconduct that is described in these proposals, then I encourage you to reject these amendments. A couple of things to discuss with regards to this proposal. First is length. The existing section 4.70 is already sprawling. It discusses vacancy triggers, discusses election timelines, it discusses nonpartisan, partisan appointments, it discusses suspensions. That is a wide variety of subjects in a single section within the charter. Any amendment to vacancies will necessitate a fairly lengthy section. Having said that, while I have been challenged with condensing here, I want to extend that challenge to everyone else to reduce the length of this proposal in a way that still maintains the accountability measures and the measures that ensure transparency and accountability in the provision of documents and other key information the public can use to make good decisions, or at least advocate for good decisions being made on their behalf. I do want to echo virtually everything that Vice Chair Lance has noted, but I also want to appeal to the public that these subsections are written in very clear, plain language. Despite the potentially contentious length, it's very readable. It is, I think, a document that allows anybody who's not a lawyer to pick it up and say, okay, this is what we're expecting of our elected officials in our government processes. We want you to request a resume and a statement of interest from your partisan candidates. We want our council to publish these materials. We want applications to be submitted so that people can read them and understand who is applying for these roles. And before anybody further accuses this document of being a partisan effort, in fact, what this document does is ensure that council has a consequence for not making a partisan selection. In fact, if there is a council and and they are given a list of 3 names, and they choose to deadlock or choose not to take any action at all, there are strict limitations that are applied to their work until the time the governor is able to appoint after 60 days. So for people who don't want gamesmanship in partisan selections, this is a very good proposal. I want to further state that any type of discussion about weaponization, that's not what's going to happen here. If you are concerned about an attorney general or some court making frivolous charges, that is a concern that is beyond the scope of this charter and our discussion here. That's a far less significant systematic problem that is unrelated to this discussion. So I just want to end that if you want accountability, this is a surefire way to do it. With very basic needs to accomplish that. We don't want officials misleading the public, fabricating documents, misappropriating revenues, or other forms of official misconduct. This is a very bare bones amendment to vacancies. And yes, there is some strategizing here to make sure that it all flows together so that there's a complete package of improvements that can be sent to the public without kind of burdening their ballot. I think we've gotten here with this proposal, and I look forward to competent, logical amendments to it. Thank you.
Commissioner Ward? Commissioner Ward, District 6. So I had concerns when this amendment was initially brought up, and I brought forward the council as rules of procedure to handle vacancies. So the charter addresses vacancies, and there is some vagueness in the charter. And then there is clarity in the council rules of procedure from day one until, the RCW says you have to have someone appointed in that elected position. So looking at your new timeline, I believe that it does not leave enough time for a careful process. To give the voters someone who has been vetted to fill the position. We talk about having, meritorious processes, competitive. That does not happen in 20 days. So I believe it does not leave enough time for careful processes. Or a vacancy in an important elected office, council may need time to receive the list of applications, publish materials, schedule interviews, gather public input, deliberate, and vote. So 20 days moves very, very quickly, especially if there are holidays, absences, scheduled conflicts, or a large number of applicants. That could pressure council into making a rush appointment instead of a thoughtful one. I also believe the penalty is extreme. If the council does not appoint within 20 days, the proposal says council must furlough advisory personnel, meet every calendar week, and transact no other business except non-discretionary statutory deadlines or emergency ordinances until the vacancy is filled or authority transfers. I have not heard that there's a problem filling vacancies at the council level. In fact, it's a very thoughtful process that they go through. I've not heard complaints from the public. So I have concerns with the penalty that is now being put upon council, so that is very harsh consequences. It effectively punishes the whole county government if council cannot agree quickly. It can interfere with other important county business. Council handles budget matters, so depending on the time of year when something like this happens, council handles budget matters, contracts, appointments, public hearings, routine legislation, and urgent county issues. So the proposal would largely shut down the work done or down over one unresolved appointment, which there is a process for. That is a serious government risk. So a vacancy is important, but so is keeping the rest of the county government functioning. So I feel like the deadline, the penalty, is unreasonable. It could also, if council members are invited, a 20-day deadline with a shutdown penalty may not create consensus. It may instead harden position, increase political brinkmanship, and force symbolic voting instead of real deliberation. I also have concerns with the council judgment. The new $1 million court judgment vacancy rule. I also share concerns with setting up the council process to fulfill a vacancy. We're looking at the state legislation, Senate Bill 5974. That's currently, there's a lawsuit against that because it subverts what's in our constitution right now, that our processes in place that are fair and transparent. I also share concerns. I'm hoping that when you look at the gross misdemeanors that are being talked about, hopefully those are the same ones that are done at the state level and with the Criminal Justice Training Commission, and don't lower the threshold so that there's consistency for the county and the state. And so, but I will be opposing this. Thank you.
All right, so that concludes discussion on the proposal as amended. So thank you, everyone. That concludes first readings for tonight. And unless there's an objection, I'd like for us to take a 10-minute recess. Hearing no objections, we will be back at 8:52.